Hi everyone, welcome to today's webinar, Mandated Reporting, Myths and Facts with Sherry Williamson. My name is Chad Sievers and I'll be your webinar moderator for today. And before we get started and I turn things over to Sherry, I wanted to kind of let you know a little bit about my program and do some housekeeping announcements. So Arkansas Building Effective Services for Trauma, or ARBEST, we are a state-funded program at the UAMS Psychiatric Research Institute, and our aim is to improve mental health services for children who have experienced trauma from events such as abuse, natural disasters, and family separation. We work really closely with our state's child advocacy centers to build a more trauma-informed mental health system, and we're probably best known for providing training to mental health professionals and treatments that are effective with helping children recover from trauma. And so that's a little bit about us and my program. And as always, just some housekeeping announcements. We really encourage you all to ask questions throughout the course of today's webinar. And to do that, there's a little question feature on the right side of your screen. And if you're interested in earning a CEU, just be sure to stick around to the very end. We'll have a code that's given, and I'll give some more instructions at that point. We are recording this webinar, and we'll plan to upload it to our YouTube channel. We have other previously recorded webinars there too, so you can check those out. And if this topic is of interest to you, or other training-related topics to child trauma, child mental health, you can check us out on Facebook, like us. We frequently post upcoming webinars there and other training opportunities. So I'm going to stop speaking and let Sherry introduce herself and her presentation today.
Thank you very much, Chad. Before I get started, I want to thank ARBEST for allowing me to present this material for you all today. I'm a very big cheerleader for ARBEST and likely the work done by most of the people who are involved in this webinar today and listening in. And that's because I'm an adoptive parent. So my name is Sherry Williamson. I work for the Arkansas Commission on Child Abuse, Rape, and Domestic Violence. I've been here for 18 years. Prior to that, I was a juvenile probation officer in Garland County for a couple of years after finishing up my undergraduate degree in psychology. And so part of the reason that I'm such a big cheerleader for you all, as I mentioned, I'm an adoptive parent, and I'm going to talk a little bit about that today during my presentation. I want you to know before I get started that my children know what I do for a living. They are okay with me sharing the pieces of their story I share in trainings. I would never share any information that they didn't want me to share. And they think it's very cool that I get to talk to a lot of the people who are in some of the fields that were able to help them out when they needed help. So with that, I'm going to go ahead and get started. So first, I want to just kind of let you know a little bit about what we're going to talk about today. This is a relatively basic and straightforward presentation. We're going to talk a little bit about basics about mandated reporting, but then what I really want to spend most of the time on is some myths that I have come across repeatedly doing trainings. I have trained more than 15,000 mandated reporters in person during the time that I've been here at the Commission, and I have noticed in doing those trainings that different groups of professionals seem to have some different ideas based on their profession. And I think some of that comes from institutional norms that we all have within our different fields. I do want to make sure you know when we're talking about myths, we're not going to be talking about myths related to child abuse. That's because there are certainly plenty of those. We're going to talk specifically about myths that I have seen come up over and over related to mandated reporters and different things that they encounter. So that's the information that I would like to share with you today. I always, whenever I have a captive audience, feel like I want to share a little bit about mandated reporting, just because I think that it's something that we can all get a refresher on. The first question is who? Who are the people who are mandated reporters? And as as you see on your screen, we currently have 41 categories in the Child Maltreatment Act, which is the part of the Arkansas Code that's dedicated to child welfare issues, child abuse issues. And in Arkansas, whether or not you're a mandated reporter is generally determined by your profession for the most part. Not always, because foster parents are certainly included. But if you look at the list, it's mostly professions. And if you're wondering why I don't include the list for you in the presentation, it is one of the things that I have learned the hard way. I used to include the list of mandated reporters in presentations, and then there's a presentation I developed, I think in 2003, when our list of mandated reporters was, I don't know, 26 or 27 professions. And it's still floating around out there, and I every once in a while find someone who's still using it and try to get in touch with them to let them know how much that list has grown. So you can see the code citation, that ACA 1218-402, that's where you can find the current list of mandated reporters if you are interested in knowing whether or not a certain group of people are mandated reporters. And we have everything on that list from the newest one added to the list, Child Welfare Ombudsman, is actually a position that's in my office that I'm going to mention to you a little bit at the end of the presentation. And that's literally at this point only one person. We have one person in the state who fills that entire category. But then there are also categories that are as broad as an employee working under contract for or a contractor of the Department of Human Services when acting within the scope of his or her contract of employment. Well, and as we know, that would be literally thousands of people in that one category. So some categories are very broad and others are much more narrow. And it is something that we have just about every legislative session, a change or two happen. So you may want to familiarize yourself a little bit with that list. I also want to mention a little bit about mandated reporting, the legislation generally speaking, and how that actually came about. The first legislation that I have found about mandated reportings of any significance was in the 1960s. And prior to that, the only child welfare issues that were really reported consistently, if that, were when there would be really severe injury to a child. And as many of you, I am certain likely know based on your profession, the majority of the investigations that are done in Arkansas, nationally as well, are neglect investigations. So those are obviously not investigations where you would consider it, for the most part, a severe injury to a child. So most of the cases that we deal with today would have not even been something that would have been on the radar in the 60s and prior to the 60s. So that first legislation was to require physicians to report. And after that, in 1974, CAPTA was passed. That's the first iteration of CAPTA was passed. That's the Child Abuse Prevention and Treatment Act. And so this is an example of federal legislation where, you know, the general idea is the federal government does basic things and then allows states to make all of their own decisions about their laws. Well, this is one of the many occasions where the federal government will tie state funding to you including certain things in your law. So CAPTA in 1974 said, basically, if you want access to this federal funding for your state, you have to have these certain professions listed as people who are mandated by law to report suspected child abuse. So it was expanded from physicians to include a couple of other categories, including mental health professionals. So that happened in 1974, and our list has just grown from there. It's generally reactive. For instance, the clergy was added to the list in Arkansas in, I believe it was 2005. I would have to go back and look. It was early on when I worked, but when I worked in at the commission, and it was added as a result of a lot of the publicity that happened surrounding the Catholic Church when a lot of that information came out. That is not in any way, shape, or form to say that child sexual abuse only happened in the Catholic Church, but it was viewed as an opportunity by a group of people who wanted clergy added to the list of mandated reporters to get them added, and so that happened. But it was reactive, and that's very often the way it does happen. Not always. So we now have 41 categories of people on our list of mandated reporters. There are more than 20 states in the United States where everyone over the age of 21 is a mandated reporter, but we're just continuing to add to our list at this point. So this is, I think, an interesting question for me that sometimes it's surprising me that I get that people, there's some confusion about what it means to be a mandated reporter. I get calls occasionally and I get emails from people asking how do they go about becoming certified in the state of Arkansas to be a mandated reporter, as if there's some specific type of training that one has to complete to be mandated by law to report. When you're, as I said earlier, you're considered a mandated reporter based for the most part, in what you do for your profession. So there's not a specific certification that then makes you a mandated reporter, though there are certain categories of mandated reporters who are required to complete training, but that's two separate issues. So in a nutshell, a mandated reporter is somebody who, based on their presence in Acts in 12-18-402 in the Arkansas Code, is required by law to mandate suspected child maltreatment. Although we do, as I mentioned, have certain training requirements for some groups of mandated reporters in Arkansas. Two of the more recent that I can think of off the top of my head, in 2007, there was an act passed, Act 703, that was sponsored by then Senator Percy Malone, that was a huge bill. I think it was about 20 pages, and it had a lot of information for the child welfare field in it, and made a lot of changes. And one of those was requiring colleges and universities to provide training on mandated reporting for degree programs within their college or university that would have some type of certification process at the end. So think about teachers have to have a license to become a teacher. Nurses have to have a license to become a nurse. So there was a flurry of activity around making sure with all of the different educational programs with Department of Higher Ed to make sure how they would ensure that they had that availability. And I remember when that legislation passed, I thought it was really interesting because we were going to have people who would grow up, who would finish college and become licensed educators required to have this training. But at that point, current licensed educators were not required to know that they were mandated reporters. And one of the theories that I was given was, we're going to get these people who are in college and very passionate and they have their hair on fire to go out into the field and to let people know and go at it that way, kind of go in through a back door. And it worked. I started getting calls from educators who had been around for 20 years saying, you know, I have this concern about a kid in my class and my student teacher just told me that I could go to jail if I didn't call the hotline to tell them what happens, what is going on. And then in 2011, Act 1236 passed, which required all licensed educators to receive training on being a mandated reporter. So those are a couple of examples of more recent training requirements for mandated reporters in Arkansas. So how do you make a report? This is very straightforward. In non-emergency situations, there is a fax form that you can use, the Arkansas State Police Suspected Child Abuse Report fax form, and you can actually just Google that and it will pull up the most recent version of it in case there are ever any changes to it. The things to keep in mind is the way that's supposed to work is obviously that it's not an emergency, that you cannot report anonymously because they're supposed to be able to get back in touch with you, although if they receive something and it doesn't, and say they can't read your phone number or whatever, they're not going to not accept it because they couldn't read your phone number. But in theory, you're not supposed to be able to report anonymously with a fax form, and you're supposed to be a mandated reporter, in theory. In any other situation, you would obviously call the child abuse hotline, and you have two numbers there. And the reason I include them both in trainings is because it was just a few years ago. It was actually the First Lady of the state of Arkansas working with the Children's Advocacy Centers, getting word out about this new number, the 844 Save a Child, which is fantastic. It's easy to remember for people who are not in the field and haven't been using that other number for a million years. It's a great way for people to remember how to make a call to the hotline. I still include the old number because I always want to remember and let people know both of those numbers go to the same place. So if you call the old number and you are on hold and then you hang up and you call 844 Save a Child, that is still going to go to the child abuse hotline where your call is answered in the order it's received. They're basically rollover numbers. So if you call one number, either of those numbers, and you are on hold, please just stay on the line because your call is going to get answered in the order it was received. It's not going to send you or route you a different way if you hang up and call the other number. I apologize profusely that I have a little bit of a delay when I'm advancing slides. So I talk 90 miles an hour and then suddenly it falls silent. And I know y'all are probably wondering whether or not your sound has gone out. That's my problem, not yours. Okay, so when do you make a report? This is the sentence that if I were going to ask to be paid per use of a sentence for my entire career, this is the one that I would want that based on. I get calls. I used to get calls all the time before educators were required to receive that training. People wanting to call, and I think many of you probably who work even peripherally in this field will get these calls even from family members based on their employment saying, something happened, I don't know if I should call it in, and then you have to tell them this. As a mandated reporter, you're supposed to report immediately if you have a reasonable cause to suspect that a child has been subjected to maltreatment. A lot of times people are struggling, if they're struggling and on the fence, they want somebody to tell them, yes, you need to call that in, or no, you don't need to call that in. When the reality is, it's incredibly important that you make a call if you have reasonable cause to suspect. Now, we're going to get into this a little bit more when we talk about one of the myths, but I have this theory that part of the challenge for people is they want to only call things in that they know are going to be accepted. And reasonable cause to suspect a child has been subjected to maltreatment is not a guarantee that something is going to be accepted, obviously, but that is nevertheless the legal standard for mandated reporters. If you have reasonable cause to suspect a child has been subjected to maltreatment, you're required by law to make that call to the hotline. Why? So I have struggled with this. You know, when you go through questions about any topic, one of the questions that you always want answered is why. And so when people are asking about calling the hotline and they're on the fence, my question is always, why not call? What is holding you back from calling? What is it, if you know that you're legally mandated to report if you have reasonable cause to suspect, why are you talking to me or someone else about it instead of just calling the hotline and letting them determine whether or not it's supposed to be accepted? So I think why is always a question we need to answer. And honestly, if you need a why beyond what Arkansas law tells you, you have to find that within yourself. You have to figure out what your why is going to be. And I thought I would share mine with you. So that is a paper cup that is in the shape of a heart. And I took a picture of that, likely through choking back sobs when I was handed that cup, because it was given to me by one of my children. We adopted our boys. We met them when they were 6, 7, and 8. The adoption was finalized when they were 7, 8, and 9, and they were chronically neglected. And so this is not just a job to me. It really, I feel like I'm a woman on a mission, because since the day I met my kids, every question about mandated reporting, every kid who needs help, in my mind, they could have been my kid before they were my kid. You know, when we had gone through the process and our home was open and we were waiting on children to be placed with us, when people would call and try to decide if they were going to call the hotline, which if you have to go to the trouble to find my number and call me, or call your local CAC or your local DHS office or a therapist, you know, to ask, then you know that you need to be calling the hotline. You don't need to be calling somebody else to talk you through it. But every time that would happen, I would think, you know, that this could be my kid that they're calling about, and I just don't know they're my kid yet. So my kids were subjected to chronic neglect for years. They were in foster care for 2 years before they came home to us. And my youngest child was in the best foster home in the state of Arkansas, as far as I'm concerned, from day one. And I'm willing to fight anybody who wants to fight me on that. And his older brothers joined him there much later, and they were in some pretty questionable circumstances between their biological family and being placed with that really good foster family, unfortunately. But so my kids, when they came home to us, were very, especially the older two, because they hadn't been put in that loving home for the whole 2 years they were in foster care, where they were treated as if they had been born into that family. So my older two children really struggle more with letting someone else take care of them and understanding that that's something that they should expect for an adult around them to take care of them. And one summer, 2 out of 3 of my children had pneumonia. And this cup was given to me by my middle child, who is now 16. He was, I think, 8. He was 8 or 9 when he had pneumonia. And he handed me that. He was sitting on the other end of the couch and just felt miserable. And I had taken off work and was home with him. And we watched a lot of TV and watched a lot of movies. And you have really never enjoyed watching Annie until you have watched a happily adopted child smack talk Miss Hannigan, which I got a front row seat for, from that child. And he handed me that, and he said, "Here, Mom, this is for you. It's a heart." And of course, I immediately started crying and said, "Well, why are you giving me a heart?" And he said, "Because you're taking care of me when I'm sick, and you took care of my brother when he was sick." And I said, "Honey, that's what we're supposed to do. We're supposed to take care of you when you're sick." And he just shrugged his shoulders. He was at a point, I mean, when they came to us, he has an intellectual disability and articulation disorder, and he was very difficult to understand and didn't know his entire alphabet. You know, just really, he benefited so greatly. He really thrived once he had access to a couple of hours a week of physical therapy and occupational therapy and speech pathology. But he really, a lot of things for him at that point were symbols. You know, he drew a lot, and he would draw stick people and with a lot of hearts around them. And he knew the letters of all of our first names, so he would put the first letter of each of our names. But so my boys are my why. And I want to make sure you all understand, I'm not suggesting that calling the hotline and children ending up being removed from the only home they've ever known is not traumatizing. It is the most traumatizing thing. I have very complex, complicated feelings about my children's birth family, but the reality is I love my kids enough that I wish that their birth family had been able to get their act together enough with the support that they were offered, and God knows they were offered support to be able to raise their children, my children, so that they would not have to have been removed. But that's not the way it worked out. But I think about this child giving me this cup and just being so amazed at the fact that someone was taking care of him and he didn't have to take care of himself when he had pneumonia. So that's my why. So we're going to talk now for a little bit about some of the myths that I have come across in this process of training all of these mandated reporters. So here's the first myth that I would hear. I call it the chain of command myth. I don't need to call the hotline because I told my supervisor and they said I don't need to call. It really just makes me twitch, honestly, especially because we've done so much training. And, I'm not the only person out there doing mandated reporter trainings. For years, Gary Glisson, who was then over the child abuse hotline, and now Dan Mack, were doing mandated reporter trainings. And as CAC spread around the state and grew into these agencies that have people who are dedicated to training and can go out in their local communities and provide these trainings, we now have so many more people providing mandated reporter training to combat some of these myths. And this one it really surprises me that I still hear it. I don't hear it as much as I used to. But the fact is that if you are a mandated reporter, no matter what your agency policy says or your school policy says or your boss tells you kind of privately off the record, if you look in the Arkansas legislation, you are not going to find some place that says if you have told your supervisor you're off the hook, right? You still have a legal mandate to call the hotline. In 2007, in Act 703, that one that I've already mentioned, they actually had to put in writing in legislation that you do not need to, that schools, Head Start programs, and daycare centers do not need to ask permission or notify a specific person before making a report. And since then, we have added that an employer or supervisor of employee identified as mandated reporter shall not prohibit somebody from directly reporting. I did a training at one of the largest school districts in the state many years ago before teachers were required to receive training, and asked in an auditorium full of licensed educators, how many of you are mandated reporters? And everybody started looking around and my heart sank. And one woman stood up and raised her hand and said, I am the mandated reporter for our school district. And I thought I was going to pass out on the stage. They had one person that if anybody thought a child was being abused, they called this one person and she would get in her car and drive from whichever building she was located to that school. So now a child is having to tell another person before a call is ever made, which is the opposite of best practices. But that school district thought that they could have this one person. And I said, well, I'm about to make your day and probably disappoint everybody else in the room, but you can sit down and take a break because you are not the only mandated reporter here. I think sometimes it's kind of viewed as a way that administrators or whomever the powers that be are in whatever environment we're talking about can kind of keep a handle on what is called in and what isn't called in if they only have to focus on one person and they know that only one person can make that call. And so there's nothing in the law that supports this idea, nothing at all. There's also nothing in the law that supports there being some type of hierarchy. If say a student teacher and a licensed educator both think something needs to be called in, or one thinks it needs to and one thinks it doesn't, it doesn't matter. There's not any type of pecking order with regard to mandated reporting, whether or not a call is accepted, which I think is another entire slide that we could add regarding myths. So this myth is one that I historically saw more often from educators and in private childcare settings. I would occasionally get a call from a teacher at a private childcare place, and they would say, my sister is a teacher and said you came and did a training at their school, and I think this kid is being abused, and I went and talked to my boss, and they said that I couldn't call it into the hotline. And, we would have a little bit of a conversation, and if I come to find out their boss is the owner of the child care place, and that family has 3 kids there, and the owner is afraid that if they make the call to the hotline that the parents will figure out it came from them and then pull all the kids out and they're going to lose that money. And now, we explain to people the importance of your legal requirement as a mandated reporter, the consequences that you can face if you fail to report, and hopefully it's helping with that. But it is something that I still continue to find myself pointing out to people. I had schools very early on years ago where they would just say, I can't I can't. I have to ask my boss because they won't renew. I'm afraid they won't renew my contract if I call without asking, which always I think makes us need to go back to our why that I mentioned. So you can just always think about that paper cup shaped like a heart. If you don't have a why of your own that you want to use, you're more than welcome to share mine. So this second myth, excuse me, is one that I historically have heard more often from school resource officers or law enforcement, generally speaking. They would say, you know, I'm not calling it in because I'm not certain and I don't have proof. I've heard it some as well from mental health professionals, although I think their challenge with it appears to be different from law enforcement, because if you think about it, that's two really different groups of people when you think about mental health professionals and social workers, and then you think about law enforcement. I think law enforcement and school resource officers, their issue, I think, seems to be kind of more confusion with the fact that they're trained on the criminal code, and the Child Maltreatment Act is kind of a different animal. So if you think about it in the context of the criminal code, like somebody stealing a car, you know, the purpose of dealing with that is to punish the person who stole the car and protect the property of the person whose car was stolen. So, excuse me, it is more focused really on punishment. And the Child Maltreatment Act, while certainly there can be punishment, there's not necessarily going to be a criminal charge related to something dealt with in the Child Maltreatment Act. You know, they may or may not be criminally charged or convicted for sexually abusing a child, but through the Child Maltreatment Act, they can separately be placed on the registry that protects other children, hopefully will protect other children from being abused, whether or not they're punished for that behavior, right? So like when you call the hotline, it's not necessarily about punishment. What you're looking for is protection of a child. And if there is also punishment of the person who hurt the child, great, but our primary focus is on protecting children. And so that makes it, I think, a little bit more challenging. And I think also law enforcement tends to focus on, you know, criminal charges and then going to court and beyond a reasonable doubt, when that's not, you know, the preponderance of the evidence and all that with the Child Maltreatment Act, that they're two different things. So sometimes they say they don't want to call something in because they're not 100% certain something happened, or they don't have proof, and you always have to take them back to that earlier discussion of, as a mandated reporter, you're required to report when you have reasonable cause to suspect. It doesn't say you have to have proof, or you have to have the actual disclosure, or you have to have an admission from the offender. It says if you have a reasonable cause to suspect a child has been subjected to maltreatment. With regard to mental health professionals and social workers, I think that unfortunately you have been put in a position, and I say you because I know there are likely many of you viewing this training, you have likely been in a position where you have seen something go sideways, and it almost feel like a child has been more traumatized after a call has been made than they were before a call has been made. And I see you and I hear you, and please trust me when I say I understand where you're coming from. But the reality is, when we go back to that legal mandate of reporting if we have reasonable cause to suspect, the call very likely still needs to be made. I've seen this sometimes from people who will really struggle with wanting certainty to the point that they are aware of Pub 357, which is the Department of Human Services publication that is used in determining whether or not a call is going to be accepted at the hotline. And the reality is, as I have said now a couple of times, what it is that's your standard for calling. The standard for accepting something at the hotline is an allegation which, if true, meets the legal definition of child maltreatment. So you see that gap between reasonable cause to suspect being what you call in, and an allegation which, if true, meets the legal definition of child maltreatment, being the standard by which a call can be accepted. And if you think about it, if they really wanted to, they could make that law be, as a mandated reporter, that you are required to report if you have an allegation which, if true, meets the legal definition of child maltreatment. And that's not what it is. I've gone round and round with some attorneys and some higher ups at different agencies who think that, you know, well, maybe you shouldn't call that in because it doesn't meet the legal definition. Well, you know, the legal definitions change, and we can't expect mandated reporters who have an entire job to do, completely unrelated to child maltreatment, to learn all of the legal definitions of child maltreatment. That's why they're required to report if they have reasonable cause to suspect. So I'm not sure that it means anything to you, but I'm always going to have your back on that. I tend to prefer that people call if they're on the fence rather than do a lot of homework and try to figure out whether or not they should call it in, because that's just not the way the law is written for you all. So if you ever need a cheerleader or somebody to back you up, I'm here, although I'm not really sure I can do a whole lot of good for you. The third myth is the judgment call, is what I really like to call it. And I have heard this honestly from every profession you can imagine, as a fill in the blank. I can use my judgment to determine whether or not it's in the best interest of the child for me to call. And the reality is there's not any discretion in the law. If you look at the legislation, there's not discretion. I mean, I have had thankfully at that point she was a retired judge, but we kind of had a bit of a disagreement about it, about whether or not a call can be made, or whether or not a call should be made. If you were a judge, if you were a medical professional. I mean, I would say if you're a medical professional and you're talking about calling in physical abuse, and because of your training as a medical professional, you are looking at marks on a child and you feel like you have, a pretty definitive grasp on whether or not it is accidental or non-accidental trauma, then by all means, rely on your medical training. But at that point, I'm going to say you don't have reasonable cause to suspect the child was subjected to maltreatment, because you are saying that you're outlining how you believe it to have been accidental trauma. So you don't have reasonable cause. But if you do have reasonable cause, then you need to call the hotline, because there really, no matter how much we would like for there to be, there isn't any discretion as to whether or not you make the call. I will point out, though, that if you read the Child Maltreatment Act, which I recognize most people don't do for fun, you will see that while judges and prosecuting attorneys are on the list of people who are required by law to report suspected maltreatment, they also, if you keep reading further down and go beyond the list of people required to report suspected maltreatment, are actually exempt from liability for failing to report, which leads one to wonder why they're actually on the list if they can't really be held liable if they fail to report. So that's just a question that I ask sometimes in these trainings, because I'm not sure. Sometimes I don't know if people are aware of that. So the last myth that I would want to point out is HIPAA. And obviously the concerns that I get for this one are generally from medical professionals. I did a training once for the School Nurses Association where they were just, several of them honestly were just really shocked to know that they could actually share information. And the reality is people think they can't share any information because of HIPAA, and you can't share any information with just anyone, but there are actually provisions within HIPAA that allow you to share if you believe a child to have been subjected to child maltreatment. When you are making a report to the agency in your state, that can actually accept those reports and investigate those reports. So if you think about it in terms of calling the hotline, yes, you can share the information. A DCFS investigator comes to you to talk to you about it because it's a priority too, and it was assigned to them. Yes, you can share information with them. Local law enforcement comes to talk specifically about that case and the allegation. Yes, you can share that information with them because they also can do an investigation related to it. Crimes Against Children Division of the State Police. Yes, you can share that information with them, right? So a coworker in the front office sees the state police investigator come in to talk to you, and then they want to know what they are there to talk about. No, you cannot share the information with them, right? Because they're not part of an investigation about suspected child maltreatment. So there are actually those exceptions in HIPAA that it's really important that we continue to share with medical professionals and, you know, school nurses and folks out in the field who would have access to information that could make a difference in whether or not a report could be accepted. So they can actually share that information. I'm gonna apologize very quickly in case you happen to hear the lawnmowers outside. My office we have lawn folks who come every Wednesday, and they've arrived and they're right outside my window. So I apologize profusely for that. If you can hear it, you may not be able to. Okay, so before I answer any of your questions, I would like to share some information with you all. I'm so excited about this. And again, that excitement is not just because of my professional history in the child welfare field, but it's as an adoptive parent. We have a new position at the Commission for the Child Welfare Ombudsman program. It's a division within the Commission, and our Child Welfare Ombudsman for the state of Arkansas, her name is Laura Robertson. She's an attorney. She's worked in the child welfare field and in the juvenile court for a long time, and she's doing a fantastic job. And Laura is the person you can reach out to when you see something going on in the child welfare field and you don't know who to call. Very likely Laura is your person. She works completely independently of other child welfare agencies in the state of Arkansas. She reviews issues and concerns related to court cases or investigations. When a child is, when assistance is requested by a child, the parent of the child, foster parent, relative, fictive kin. She is going to, at the end of each year, I don't know if it'll be calendar year or state fiscal year, write a report about the child welfare system, barriers in the child welfare system, things that have come up that people have brought to her attention that they don't know who can fix it, and it may even be something that she doesn't have access to fix it, but she will be able to then get the need for there to be a solution on the radar of the people who actually write the laws and determine where funding is going. She has her contact, I've put her contact information, her direct office line, and her work cell phone here. We have submitted information and been begging to have our website updated, but it is above and beyond our control as to when that actually happens, because we have a complaint form we want people to have access to that you can then fill out this complaint form to bring information to her attention. I know I've had people ask me things like, if a child is in DCFS custody and they are in a residential treatment setting and have been there for a really excessive amount of time, and we can't, you know, they can't get anybody to give them a straight answer about what's going on with the child, and, you know, they don't have an actual parent that they can ask. They have caseworkers, and maybe they don't know who the caseworker is. They can contact Laura, and she has access to all the information and all of the people who would be able to answer those questions. So she's really excited to be here and to be working to improve services in the child welfare field. And I hope you all will take some time and get to know a little bit about the program. She has brochures that explain the program in more depth. If you want those, you can call her office number. You can email me and give me your address and tell me how many brochures you want, and we will get some brochures sent to you to give you more information about the program. I'm going to make myself shut up about it because I could go on about it for the whole rest of the time because we're so excited to have her here. I mean, I've seen so many situations over the years where we know a kid needs help, but we don't know exactly how to help them. And I think she's going to be able to fill in a lot of those gaps. So her contact information is there. You also have my email address. If you email me, please notice that my last name is Williamson. There's a very nice lady who worked at UAMS whose name is Sherry J. Williams, and she used to get really freaked out when she got emails about child abuse because she worked in accounting. So with that having been said, Chad, I'm going to stop talking and you can let me know if you have any questions for me.
Yeah, thank you, Sherry. Yes, a few questions did kind of come in, so we'll take a few questions and then I'll advance it to the CEU slide. A lot of these questions that have come in, Sherry, are I'm sure ones that a lot of us have. So the first is, how can we follow up on a report, or is even that possible? Like, for instance, if you report on an issue of alleged physical abuse by a parent, after the call is accepted, is there a way to follow up to see what the results were, investigation? Can you speak to that a little bit?
I can, although I'm sad to say I don't have very good news for anyone about it. There was a time that if you were a mandated reporter and you called the hotline and a report was substantiated, you would receive snail mail. Basically, you would receive a letter in the mail saying that what had happened. And then at some point, there was I'm not an attorney, so forgive me when I mess this up, but there was some sort of an issue with due process, with people being placed on the central registry and information going out saying that something had been substantiated against them and they had not had the opportunity for due process to determine whether or not there was going to be an administrative hearing for them to try to get it overturned. And so basically it came to a point where they said, by the time we would send out, once due process all of that had happened, you're looking at several months down the line, so they weren't going to do it anymore. So unfortunately, that's one of the challenges with making this call, especially if you've developed a rapport or a relationship with the child and possibly the family or non-offending members of the family, that then say a child care worker makes a call to the hotline and then the child is pulled out of the child care center and they never know what happened. I think that way about my kids sometimes. I think when my kids were taken from their bio family, the people who were calling the hotline, I wonder if they just wonder whatever happened to those 3 little boys because they just, kind of disappeared. So there's not specific information that you're going to be given, even if you're a mandated reporter once you've made that call. If you have additional information to share, you can always call that back in. And if you, the idea during an investigation is if you've given your information that they're going to contact you with follow-up questions, which may or may not happen, but there's not some specific information that you're going to have access to anymore. Some of you may remember when that was a different case.
Thanks. And these next set of questions, there's several questions about the fax form. So, and after this question, I'll go to the CEU slide. But can you maybe kind of clarify like when to use the fax form? So like how to determine when you have to comply with the mandate to report immediately versus when faxing, et cetera. So should we just kind of defer to the hotline number, or should we go to the fax, faxing things in, just some guidance on that?
Sure. I would say if you're on the fence and you don't know whether or not to use the fax form, to go ahead and call. The idea with the fax form is to try to free up the phone. So say a school counselor or a mental health professional in one office has a child sitting there who has now disclosed because she's away from the offender, she feels safe, she feels more comfortable, and discloses that she was sexually abused by, say, an uncle who just went to prison. And she tells her therapist this. So now we know the uncle is in prison. He's not going to sexually abuse any other children right now, right? So no child is in danger from him. So you could fax that in. So say another child says she's afraid at a school, she's afraid to get on the bus and go home because her stepmother came in her room the night before and was touching her inappropriately and sexually abused her. So that is an emergency. So, I mean, actually, that's enough of an emergency to call local law enforcement about, but you're definitely not going to use the fax form when there's a child who's still exposed to an offender. It's very often, from what I understand, used for situations where somebody is disclosing something that maybe happened a long time ago. But if you're on the fence, I would say definitely call instead of use the form.
Thanks. And we have some more questions too, but just briefly, if the folks on today's webinar are interested in getting a CU, the code for today is 1304. It's up on the screen now. And so after we're done here, I'll send an email out to everyone who registered and attended today's webinar, and you can just enter that code in and you'll get a CEU. So I'll keep this slide up here for a little bit and we'll take a few more questions if that's okay, Sherry.
Sure.
So another kind of question I think a lot of us have is, and maybe this is a myth, I'm not sure, but is it accurate that, you know, multiple reports and they're not accepted, but they're documented and they might eventually stack up, creating enough concern to an investigation, if that makes sense?
I'm thinking about how that's worded. Each individual call is supposed to be taken completely on its own merit, from what I understand, but I also have a very hard time thinking that if there are multiple calls that almost rise to the level of acceptance and then finally one does, that there's not going to be any consideration taken for the other ones. It is definitely documented. And if there ever, whether it's because it's possible for enough reports to pile up or not, let's say that there are a bunch called and not accepted for investigation, and then finally one is called and on its complete own merits, it's accepted for investigation. Because the others were documented, they're still going to have access to that information. Does that make sense?
Yes.
So I'm not saying that enough almost accepted piled up for them to say we're going to accept one, but if one happens to be accepted, everything else has been documented that has come in.
Great. And I know there's sure we have more questions than we have time for, so I'll back up here in a bit to, you know, the email address and contact information.
Sure.
But I'll do another question here and we'll kind of back up to that slide. Oh, I just lost it. Oh, so what about you here at second or third hand, and you're a mandated reporter? Is it your obligation now to, you know, report this allegation of child maltreatment? You've heard
that's a great question, and it's one that I get a lot, and it is another one that I've kind of gone round and round with a couple of attorneys about, because they'll say, well, no, you're not supposed to report second or third hand information. And then my question is, where in the law does it say you're only supposed to report if you've heard it directly from a child? And it doesn't say that in the law. And I absolutely know of cases where someone has reported something second or third hand and it was accepted for investigation and it was investigated and it was substantiated. So I'll say this, if you don't make a report and you say, well, it was second or third hand information, it's not an actual defense to say it was second or third hand information. That's not going to make somebody say, oh, okay, well, we can't prosecute you or we can't sue you civilly because of the way the law is written. I have had people say, I heard it second or third hand. I don't think it actually happened. I didn't talk to the kid. I don't, like, you could tell by the way they're talking about it that they don't believe that the child was they don't think they have reasonable cause to believe the child was subjected to child maltreatment, so they don't call it in. But there is not something in the law either way that says you have to or they can't accept it.
Okay. And another question that came up a couple times is, what about past abuse? You know, for example, an adult is reporting they were abused as a child. What do we do there?
Well, there was a 2-year period where they made it to where if an adult discloses abuse that occurred when they were a child, there's a certain group of people who can actually get that accepted to the hotline in very specific circumstances. And there was a 2-year period where therapists were on that group, were in that group, mental health professionals, and they got themselves taken out of it. But there are still group categories of people who can get that call accepted in very specific circumstances, like law enforcement, the survivor of the child abuse, the offender. I believe there's a 4th category that I can't remember off the top of my head, but it will also only be accepted if that person cares for children now. And the challenge we always had with it is, what if you don't know? I mean, therapeutically, if you have an adult who's saying, I was abused as a child, I want to report it, I think it would make sense to me to encourage them to report it, even if it can't be accepted, because you don't know, you don't have contact with that person to know if they care for children. So yes, it can be reported, but it can only be accepted in very specific circumstances.
Great. And so would you say maybe just to defer to call the hotline anyway and make them determine that versus, you know, trying to decide whether or not to report? Would that be fair to say?
I would say so. I mean, because the reality is mandated reporters are required to report if you have reasonable cause to suspect. So you have an adult victim telling you this happened to me as a child, you have reasonable cause to suspect. But then you also know that it's not likely to be accepted based on these really specific circumstances. So it's really I would say, a matter of preference. I mean, personally, I would go ahead and call it in, or I would suggest to that victim, if they feel empowered to do so, to go ahead and call it in. But that's my personal take on it.
Great. And just again, the CEU slide is up here. Today's code is 1304, so just jot that down, and I'll send an email out after we're done here. And maybe just one more final question. Just kind of looking here. Oh, I just had it. Sorry, there's lots of questions that came in. So this is maybe a good final question to end on. So when suspected abuse or neglect is reported, is that usually done with or without a conversation with the child about the report? What's been your experience on that, Sherry?
I'm sorry, I'm not certain I exactly understand the question. Is it because when they say a conversation with a child, do you think they mean the child disclosed something that told them the child was being neglected, or they told the child they called the hotline, or they just?
I think the latter, yeah, that they let the child know that they made a hotline call. Is that usually something that is done or is not done, that conversation?
I have heard of people in different professions handling it both ways, honestly. I've heard it both ways, and I have heard people say I absolutely would never tell a child to call the hotline, and some say I would never call the hotline without telling the child. So it's not really something that I can tell someone one way or another, especially, my goodness, especially mental health professionals, because they have, you know, their ethical requirements and all of that to deal with as well.
Thanks.
Sorry, I don't have a lot of help with that one.
No, I think it was a great question to ask, and I know there's a lot of a variety of professions on today's webinar, so we've got a big group today. So I'll maybe back it out to the contact information. Sherry, I just want to thank you again for presenting today.
I was happy to. Thank you all so much for the work you do.
All right. So Sherry's email is up here. Copy that down if you have any kind of follow-up questions. I'm sorry we couldn't get to everyone today. And I hope everyone has a great day.